To order again. Well, thank you very much for that background. Now we go to Tousaw Law Corporation, Kirk Tousaw, by video conference. Have I said your name right?
Yes, you did. Thank you.
Okay.
Chair and members of the committee, my name is Kirk Tousaw. I'm a barrister based in British Columbia, formerly practiced in the United States, which perhaps is why I'm on the international panel. But I represent clients across Canada exclusively in cannabis law and policy, and have done so for the past decade. My firm currently acts for hundreds of people charged with cannabis offenses in Canada, many younger, few with other criminal records, and all of whom do not deserve to be treated like criminals for their cannabis-related activities. I was part of the legal team that successfully challenged the prior medical cannabis regime on charter grounds in the Allard case and litigated R.V. Smith, the only medical cannabis case to reach the Supreme Court of Canada. It resulted in a unanimous per curiam decision finding the CDSA unconstitutional because of its prohibition on access to medical cannabis derivative products. I commend the Government of Canada on its decision to move towards a rational and empirically based model for production, distribution, and possession of cannabis by Canadians. Before making substantive comments on Bill C45, I'd like to take a moment to speak about why Canada is taking this important step. The Government of Canada posits two main reasons for legalization: to protect young people and to eliminate the black market. As a father of four, ages 7 to 17, and you may hear them outside the room later today, I certainly agree that protecting young people is an important social goal. The best way to protect young people is to stop criminalizing them. By far the most harm done to young people related to cannabis is done by the criminal justice system, not the use of the substance itself. As a lawyer who has represented hundreds, if not thousands, of people unjustly charged with violating the cannabis laws of both the United States and Canada, I support eliminating the black market in the sense of allowing those that are now involved in the cannabis industry or wish to be involved to do so lawfully. When we speak of the black market as it relates to domestic cannabis production and consumption, we are not speaking of what most Canadians understand to be organized crime. We are not speaking of gangs. Instead, the domestic black market is comprised almost exclusively of ordinary Canadians, otherwise law-abiding, that make their living, pay their bills, and support their families by working in the cannabis industry. They do so for a variety of reasons. Some are committed to the plant and the cause. Some are entrepreneurs, employers, and small business people that simply want to be part of a vibrant industry that produces a product that brings people joy with very little in the way of negative effect. Almost none are violent or otherwise harmful to society in any way. And so while I agree that eliminating the black market is a critical goal, I strongly urge this committee and the governments of Canada and the various provinces and territories to understand elimination to be synonymous with transition and not with incarceration. This includes provinces like Ontario that are moving towards a misguided and unworkable government monopoly on retail sales. Private dispensaries are preferred by consumers, both domestically and in other legal jurisdictions, internationally, and already do a great job providing dignified, reasonable access to cannabis. There are other, more important reasons to end cannabis prohibition. Canada is a constitutional democracy committed to notions of individual freedom and individual responsibility. This requires allowing Canadians to make autonomous decisions about their own bodily integrity without undue interference or criminalization of their choices by the state. Prohibition has caused incalculable harm both to society and to individuals entangled in the criminal justice system. 26,000 Canadians were charged with simple possession of cannabis just last year. Many will have difficulty crossing the border into the United States. Over the course of this failed policy, hundreds of thousands of Canadians have been criminalized to no good end. Each time a Canadian is arrested, handcuffed, and caged for cannabis-related activity, an injustice is done, harm is caused, and we all suffer. Moreover, cannabis prohibition detracts from respect for the rule of law. Millions of Canadians violate the law by possessing cannabis each year. Some of these citizens have achieved positions of great prominence in our society. That is because either through accident of luck, social or racial privilege, or powerful connections, they've been able to avoid entanglement in the criminal justice system. Hundreds of thousands of Canadians are not so privileged. When millions of otherwise law-abiding and decent people feel it unnecessary, impractical, or harmful to obey the law, respect for the rule of law suffers. And when police officers are tasked with enforcing laws that are ignored by millions of Canadians, the relationship between the police and the citizens suffers. It is far past time to right these wrongs. Amnesty for Canadians charged with cannabis offenses is long overdue, and I urge this committee to recommend amendments to Bill C45 that would eliminate the criminal records of, at minimum, those convicted of simple possession of cannabis. This would go a long way to restoring their ability to travel, in particular to the United States. Turning to the substance of Bill C45, I say with regret that much work remains to be done. This bill takes us in the right direction, but does not, and in its present form cannot, achieve either the goals that I have identified or the goals that Canada seeks to accomplish. Bill C45 continues to criminalize young people for possessing more than 5 grams of cannabis, an extraordinarily small amount. It is very likely that post-legalization, thousands of young Canadians will continue to be entangled with the criminal justice system, doing irreparable harm to the future course of their lives. I agree with age limits related to sales of cannabis to Canadians by commercial entities. Parents, not shopkeepers, should be making these decisions. Age limits for sales, however, is an entirely different thing than imposing criminal penalties on young people for simple possession. I urge this committee to recommend amendments to Bill C45 to remove any possibility of criminal penalties being applied to any young people in this country for activities related to cannabis. Bill C45 also contemplates criminal penalties being applied to adult Canadians who possess more than 30 grams of cannabis or grow more than 4 100-centimeter plants per household. These are arbitrary numbers. These criminal restrictions are decidedly unlike the way that our country regulates alcohol, a vastly and arguably more dangerous substance than cannabis. At this moment in Canada, a 19-year-old can walk into a liquor store and purchase enough alcohol to kill that person and all that person's friends and acquaintances. Indeed, there's enough alcohol in 1 bottle of vodka to kill the consumer. Similarly, there are virtually no restrictions on individual Canadians' rights to brew beer or make wine for their individual consumption or for non-commercial sharing with friends and acquaintances. Canadians can also currently grow 15 kilograms of tobacco per year, enough for some 15,000 cigarettes. Given that reality, it is ludicrous, or to put it in legal terms, arbitrary, overbroad, and grossly disproportionate to allow Canadians to be arrested and caged for simply possessing any amount of cannabis, or for possessing cannabis deemed to be illicit, which is, in any event, a wholly unenforceable distinction. There is no empirically, morally, or legally sound reason why cannabis should be treated more strictly than alcohol. There are also practical difficulties related to these arbitrary restrictions. Cannabis, particularly outdoors, can easily grow 5 or more meters high in its natural state. Do we really need or want a rule that would require Canadians who wish to grow a few plants in their gardens to continually tie down the branches or otherwise artificially manipulate the plant during its growth to keep it no more than 99 centimeters high? 100-centimeter limits are the height of absurdity. In addition, the 4-plant per household limit arbitrarily penalizes those living in large households. These limits, backed by criminal sanctions, will certainly lead to legal challenges based on Section 7 of the Charter of Rights and Freedoms, which requires the liberty of Canadians not to be infringed by arbitrary, overbroad, or grossly disproportionate laws. The restrictions on possession amounts and plant numbers and sizes for personal, non-commercial production of cannabis also detract from the goal of eliminating the black market. Allowing Canadians to be self-sufficient and to obtain their cannabis by growing for themselves supports the transition away from reliance on the black market. I urge the committee to recommend amendments eliminating limits on what Canadians can possess or grow for non-commercial purposes and removing the artificial and unenforceable distinction between licit and illicit cannabis. At the very least, possessory limits should be increased substantially, and plant limits should increase and be calculated per person, not per household. Also critical to ensuring a workable transition away from the current vibrant, enormous, but unlawful market for cannabis in this country is to make the process of becoming a commercial producer and distributor of cannabis as easy as reasonably possible. Most details related to becoming a commercial producer of cannabis are not contained in the bill and are instead left to regulations to be determined. If those rules mirror the current situation involving production for medical purposes, they will be too onerous. There will not be enough people or companies able to participate. There will be an insufficient amount of lawfully produced cannabis available to Canadians, and the black market will continue to thrive. The black market will also continue to thrive throughout the entire supply chain, from production to processing to sale, if legalization does not include products that are becoming increasingly popular. Edibles, concentrates, and products like vape pens must be legal. trends in Canada and other international legal jurisdictions, in particular in the United States, demonstrate the increased popularity of these methods of consumption, which are also potentially less harmful to the consumer and less bothersome to non-consumers. And on a practical note, there are literally hundreds of companies operating in Canada making these products right now in a professional, safe, and sophisticated manner. These products are not going away and all rely on someone growing the raw plant material to make them. If they are not legal, then as always, consumer demand will be filled by persons operating outside the law. Better by far is to allow the existing industry to come out of the shadows and into the light. I urge the committee to recommend amendments to Bill C45 that legalize cannabis derivative products, eliminate barriers to entering the lawful industry for persons currently participating in the unlawful marketplace, and to carve out from federal oversight the intra-provincial production and sale of small batch craft cannabis. Thank you for the opportunity to address the committee, and I look forward to your questions.
Well, thank you for your very clear presentation.
Mr. Tousaw, I think you made a comment that you don't think Ontario's plan to have this government monopoly is workable. Could you expand on that?
I certainly could, and thank you for your question. There are a number of practical difficulties with a government monopoly coupled with a federal jurisdiction over production. Let's take a simple example. Presumably, the government of Ontario is seeking to exert its purchasing power to try to negotiate lower per gram costs of purchasing cannabis from the federally licensed producers. If those federally licensed producers, all of whom currently have direct-to-retail distribution systems in place, are not satisfied with Ontario's offer to purchase the cannabis, they may well just decline to sell to them, in which case consumers in Ontario will essentially have no access to cannabis through Ontario's government monopoly model. Certainly, if I were running a licensed producer and Ontario tried to come in and suggest to me that I should sell to them for $3 or $4 a gram, and I'm selling direct to consumer currently in other provinces for $8 to $12 a gram, why would I sell to Ontario? And then you have a situation in which residents of Ontario either don't have access or they have to go through the artificial step of obtaining a doctor's prescription so that they can then access the medical cannabis model, which would give them direct access to the licensed producers. That's one small problem among many. Another problem is that there's already a very vibrant distribution system operating in the gray market in Ontario. There's probably somewhere in the neighborhood of 100 to 200 private dispensaries selling cannabis to consumers in Ontario right now. These entities are not just going to disappear. And if you don't transition the black market into the lawful market, then you're setting up a system of competition. The only way to shut down the competition is through the use of likely draconian police state tactics. Prohibition hasn't stopped any of these people from doing what they're doing. In fact, prohibition has led directly to the situation that we find ourselves in right now. So there's just no practical way. And here's what I think the fundamental misconception is. I think a lot of people think that legalizing cannabis is the creation of an industry. It's not the creation of an industry. The industry exists. It's vibrant. It's massive. There are literally thousands and thousands of people engaged and working in this industry in every province in this country. There are millions of different products out there. There are very sophisticated businesses working in this sector right now. And so we're not creating an industry. The best that we can hope for is to compete with the existing industry. And the best way to do that, as I say, is to transition those people that already have the expertise, that are already doing the job and doing it quite well and quite successfully, into the legal marketplace. Anything else is likely doomed to failure.
I think I'm out of time.
Yes, thanks very much. Mr. Davies.
Thank you, Mr. Tousaw. I'm going to be directing most of my questions at you. So I'll start with you. I think you very articulately described the problems with criminalization, and I think to give the government credit, I think that's something that it itself has recognized and is some of the fundamental rationale behind this bill. I think Prime Minister Trudeau has recognized that criminalization has simply pushed products underground and led to the creation of an illicit market that doesn't really work. You've also pointed out, though, that this bill, Bill C45, essentially retains a criminalized approach to cannabis. It is criminal sanctions for possession over 30 grams. There's criminal sanctions for growing more than 4 plants. There's criminal sanctions for selling, in fact, with penalties up to 14 years. So if criminalization doesn't work generally, my question to you is it not somewhat misguided to sort of take a quasi-criminal approach to C45? Or are we going to have problems down the road with the maintenance of the criminalized approach in this bill?
Oh, I think we're absolutely going to have problems with maintenance of a criminalized approach in this bill, and I think it's not just a little bit misguided, it's deeply misguided. Now, I think that there are probably some practical and some political reasons why the government has chosen to proceed in this fashion. The political reasons are quite clearly to legalize cannabis and to try to deflect political criticism from typically the right, but some aspects of the left, about this process and these steps that we're taking, and to try to therefore do it in the most small c conservative way possible. The practical consideration may well be that we know the Supreme Court of Canada, in a ruling in the Malmo Levine case, said that Parliament retained the power to prohibit simple possession of cannabis as an aspect of criminal law power. If this is not a criminal law enterprise, it becomes a little less clear what the jurisdictional basis for the federal government's involvement in this area of commerce actually is. I think those are surmountable obstacles. At the end of the day, I think we need to look at just some fundamental fairness. Cannabis is safer than alcohol. Fundamentally, empirically, that is beyond question. Cannabis is safer than tobacco. There's no good reason why we're going to treat cannabis in a way that's significantly more strict than we do alcohol. Alcohol in our society is a source of tremendous harm, and it's also a source of tremendous pleasure and joy. I enjoy a good glass of wine. I like to go to my local vineyards. I'm a regular patron at the brewery, small craft brew pub down the street from my house. I have a keg of their beer in my garage. I'm not anti-alcohol. But I recognize the harm that it does to our society. All of those things, by the way, the vineyards down the road, here in the Cowichan Valley, we have probably 20 wonderful vineyards, many more in the interior of our province. The small craft brew industry that's rapidly growing here in British Columbia, those are provincially regulated enterprises, as well they should be. The federal government's role really ought to be minimized in this area. And quite frankly, with the greatest respect to what the government's done so far, it hasn't done a very good job regulating access to medical cannabis. The medical cannabis system that was started by court order in 2001 has been struck down by the courts repeatedly in litigation that I'm sure has cost the government of Canada tens of millions of dollars.
I'm going to stop you there because I've got a few other questions. I want to talk about edibles, sure, concentrates, and other non-smokable products. Again, as you know, the government has not included those in this bill. I've gotten a number of different answers from the government. They say that it could happen imminently. It's down the road. They didn't have time to do it. I'm not quite sure. But given Colorado's experience and Washington and Alaska's with successful regulatory regimes about edibles, do you see any reason why we shouldn't put edibles and concentrates into the legal framework now? And what are the consequences of not doing so?
Well, in fact, there's every reason to put those products into the legal framework. The consequences of not doing so are the continuation and perpetuation of the black market, all the way from growing the raw plant material that you use to make the products through the point of sale. And in fact, we're seeing this even in municipal jurisdictions that are regulating cannabis dispensaries but have taken the step of banning edibles. People want these products. Consumers want these products. And anytime consumers demand a product, someone's going to rise to fill that demand.
Now, you you described the majority of people involved in the marijuana industry as law-abiding, nonviolent, entrepreneurial. These are the black market we talk about, really. I mean, there's a tendency to think Hell's Angels and organized crime, but you described a very different picture of the thousands of people who are currently involved in this industry. And you have said that we have to remember that virtually all of the cannabis produced and sold in this country right now is done so unlawfully. But if the government wants to eliminate that portion of the industry, this bill is not the way to go about doing it. Can you expand on that? Should we bring those people into the legal market? Does C45 do that? And if not, what should we do to help facilitate that transition?
Not only should we do that, we have to do that for this to be successful in eliminating the black market. The fact of the matter is that there are tens of thousands of people, if not hundreds of thousands of people involved in the illicit industry today. I've represented many of these people. I'd invite them all to my home to have dinner with my family. They're wonderful, good people, and there's no reason for them to be considered or lumped into this category of organized crime with its connotations of violence and gang-related activity. That's just not what's going on. I think in perhaps thousands of disclosures that I've seen in criminal cases, a small fraction have contained any evidence of any involvement with what Canadians traditionally believe is organized crime. And you've heard from Professor Boyd, I believe, and his research in this area that shows 95% of people are not involved with organized crime. So how do we bring them out of the shadows and into the light? Well, we have to make it easy for them to participate. We have to get rid of some of the onerous barriers to access that exist in the medical production system, the unnecessary security requirements, the government micromanaging and requiring 800 or 1,000-page standard operating procedures to be provided in order to get a license. The government should be setting baseline standards that private enterprise has to meet. If you meet those standards, you get to participate in the illicit or in the new licit system. And that's how we do it. It sounds simple because it is simple, but we need to get rid of this sort of paradigm of considering people that are in the cannabis industry today as somehow criminals that we have to prevent from participating in the future. They're not going to stop. Why would they? Prohibition hasn't driven them out of business. Legalization certainly won't.
Time's up. Time's up. Now we go to Dr. Rialson.
All right, thank you very much, Chair. Thank you all for coming. Just as a little bit of a side on international law, yes, you can be banned from the United States for saying you smoke pot, but and I just looked this up, you can be banned from the United States for admitting to be a member of the Communist Party, and that is still the law today. So whatever that says. So, Mr. Tousaw, I'm speaking. I'm sorry if I said that incorrectly. And keep in mind, I'm coming from the point of view as a staunch supporter of the legalization of cannabis, but I have to take exception to something you've said about those who participate in the illegal market or the black market. And again, I cannot paint all with the same brush. There are some gentle people who are just simply entrepreneurs, but I spent 17 years practicing emergency medicine in Winnipeg when it had the dubious distinction of being the murder capital of Canada. I looked after an unconscionable amount of violence, including gunshot wounds and stab wounds. A large proportion of that was, in fact, the black market in drugs, and most of that was cannabis. And that was all verified. So I think we have to caution our judgment as to what we call the black market and understand there is a very dark and dangerous element to this, and this is part of what we want to control and undermine. Now, one of the things that you had said in your submission was you did not want a government monopoly. You said that Ontario's plan was very ill-advised. However, experience in Colorado and Washington had shown that when you undercut the price, or when you keep the price low, you can undercut the black market, and in fact that's working very well. Colorado is now at least 70% of their market is now legitimate and may be trending to close to 90%. If you had a government program that was not profit-driven, would that not be a more efficient vehicle to sell this in a way that's not profit-driven and therefore can keep the price low and undermine the illegal market?
Well, let me just point out the Colorado system is a system of private enterprise, not a government monopoly. So that's.
However, on that, I should just point out that that was not by choice, but so that they wouldn't violate federal law. But please go on.
Well, it was by choice of the voter. But be that as it may, I think government doesn't have a particularly good track record of competing with the marketplace. Here's the difficulty. Many of these suggestions may be all well and good if we were starting with a tabula blanca, if we were at a clean slate talking about something that had never been done before, never been seen before. But we have an existing massive industry in cannabis in this country. And the government monopoly is going to compete with that industry. And it can either compete on price and customer service and attractiveness, which is going to require some advertising, some things that the government may not want to do, or it can compete using the police forces to try to enforce its monopoly, which is something that is going to offend the Charter and I think should offend anybody that believes in a free and democratic society. So many of these suggestions might make sense in a vacuum. They don't make sense on the ground as we sit here and stand here today. It's sort of like talking about the treaties. Canada's been in technical noncompliance with these treaties since it began to sell marijuana by not collecting it through private enterprise since at least 2005. So we're already in violation of all these treaties. These treaties are also responsible for creating a paradigm of prohibition that's led to the international black markets in all these drugs and devastation, destruction, and death across the world, including the opioid epidemic that's ongoing everywhere in this world, and particularly in this country and the United States. So we're not starting from a blank slate. We're starting from trying to claw our way back from a failed system that does a tremendous amount of damage.
However, if I may interject, on the opioid crisis, a huge contributor to that was over advertising by a private company that was selling OxyContin.
The overprescription of opioids is definitely a big contributor, but the reason people are dropping dead in the streets is not that. The reason people are dropping dead in the streets is because they can't get clean product of known potency because of prohibition.
Mm-hmm. All right, yeah, thank you. I have no further questions.
Mr. Tousaw, you made a comment about the home grow aspects of C45, especially with the very prescriptive charges about heights of plants and that sort of thing, that they violated or that you thought that they would get a court challenge under Section 7 of the Charter. Can you elaborate on that a bit?
Well, Section 7 of the Charter requires Canadians not to be deprived of their liberty, in particular, by laws that are arbitrary, overbroad, or produce grossly disproportionate consequences. So if you have a person in a household, say of one, and they're able to grow 4 plants legally, and then you have a person in a household with 2 adults, they can still only grow 4 plants legally, but let's say they grow 6. Their liberty could be infringed because of that 4-plant per household restriction. That seems to me to be utterly arbitrary, and it certainly captures conduct that is overbroad. In other words, it does nothing to further the goals of the legislation, the purposes of the legislation, and it unjustly and unnecessarily criminalizes Canadians who engage in that conduct. And I expect that if we have these arbitrary limits in place, the first person stopped with 31 grams instead of 30 grams in their pocket, the first person that grew 5 plants instead of 4, I'm happy to take those cases, and I expect to win those cases. I don't want to continue to fight these battles in court. I sort of thought that by legalizing cannabis, I'd be out of a job as a criminal defense lawyer. But they're subject to challenge. I think the challenges are easy to make out. And I just think, what's the point? You can brew as much beer in your basement as you want and give it away to your friends. Why should cannabis be any different? It's safer, and frankly, it's easier to make.
It's certainly problematic. I have a question about secondhand smoke. We had some discussions about what to do about secondhand smoke. Is anybody aware of anybody in any other jurisdiction internationally that has a regulation with respect to secondhand smoke?
Most jurisdictions seem to ban
cannabis?
Yes. Or tobacco that we could pattern something after.
Most legal jurisdictions ban public consumption of cannabis. That's, I think, an argument in favor of designated consumption spots like vapor lounges. I think that's an important component of legalizing cannabis. You have to give people a place to consume it socially.
Great, thank you. Question for Mr. Tousaw. So I want to drill in a little bit more, as well as Dr. Ellefson said, about black market activity. So my riding is Lower Mainland riding of Coquitlam, Port Coquitlam, and it seems it's a public perception that there is a great deal of violence, gang-related violence in the Lower Mainland,
and it is a public perception that that is related to the illicit pot market. Would you say that's an incorrect perception? And if so, what do you think is driving that activity?
Well, I think it is an incorrect perception, and I think the empirical evidence, particularly what Professor Boyd, I think, shared with the committee, demonstrates that about 95% of people involved in the cannabis trade are not involved in organized crime, as that term is commonly understood by Canadians. Undoubtedly, there's too much gang violence. There's too much fighting over the street corners. But by and large, that's not about cannabis. That's about other substances. The problem, of course, is that we continue to take a prohibition-based paradigm to the use of substances or certain substances by Canadians. The real solution to gang violence is to end drug prohibition entirely and to take a more focused public health approach to drugs generally. I do want to say a little bit about public health, though. Public health isn't just about the health consequences or benefits of using a particular substance. Public health also includes considerations of undue and unnecessary criminalization of people, use of the courts, use of the legal regime, misuse of police resources, distrust between the police and the policed, and all of those things are amplified by taking some sort of restrictive approach to people accessing relatively safe products like cannabis. I know we can say over and over again there's not a lot of research. It's the most heavily researched illicit substance in the history of humanity. People have been using it for millennia. There are not a lot of significant negative health outcomes associated with the use of cannabis. People have been smoking hash for thousands of years, which is high-potency cannabis. So I think we need to be a little cautious about making claims about perceived possible future harms. The history of humanity demonstrates otherwise.
Okay, thank you.
Okay, thank you very much. Time's up. Mr. Davies.
Thanks. I only have about 5 minutes, so I'm just going to sort of make a brief response to Mr. Rolls and Mr. Kilmer on your comments on edibles, because I find it quite astonishing. You each seem to argue that it's not essential or even desirable to legalize edibles or other products because of, here's what interchangeably you said, because of the difficulty, the complexity of titrating and dosing, and in other cases because we don't understand the public health impacts. So you're content to leave that to the black market where there's absolutely no regulation whatsoever. That strikes me with greatest of respect as absurd. So we're going to leave these products to the titration and dosing of people operating in the black market, because we know that we've heard evidence that 30 to 70% of the consumers consuming cannabis are using these products. So it strikes me, if you're really concerned about public health, you would absolutely want to bring those products within the legal regulated market, where Colorado has brought in, you're quite right, Colorado legalized edibles and other products, and they had an initial swift outlay, and then they learned the lessons and came back with regulations on single servings, child-proof containers, stamped products, no products marketed to children, known dosages, even concentrations. That's what Colorado does now, and you seem to be arguing that, no, let's not do that, let's leave that to the black market, where none of those things can happen. And the other point I would just make about leaving it to baking at home, well, baking at home, I mean, you have absolutely no ability to control dosage or concentration. So I just want to make that statement. Mr. Tousaw, I want to turn to you about, do you have any experience with Canadians being denied entry to the U.S. simply by admitting that they used cannabis?
I don't have any direct experience. I have some anecdotal experience with that. It's generally speaking, it's hit or miss. I have clients that have convictions for trafficking offenses of cannabis that have no problem going to the United States. I have people that have merely been charged but not convicted with cannabis offenses that are denied at the border. It's really left up to the whim of the individual border guard, and unfortunately, it's a thorny problem. There's not a legal solution necessarily to it. It involves political change in the United States, and it involves Canada perhaps taking a stand on behalf of its citizens to say to the United States, look, we're your biggest trade partners. We're your most important allies. We share a long border. Stop banning our citizens from entering your country for negligible reasons.
That's right.
Mr. Tousaw, just quickly, what about the fact that the federal government is still prosecuting people today? Any advice to the government on what you'd like them to do?
It's a travesty. There are 26,000 Canadians saddled with criminal records for simple possession of marijuana last year while we were moving towards legalizing this product. Their lives are irrevocably harmed by this law. And I just want to underscore what I said earlier. Canada has been in technical noncompliance with the drug treaties since at least 2005, when it allowed private companies to begin selling medical cannabis to Canadians without the government collecting and redistributing all of that cannabis. So we've been violating these treaties for a better part of a decade. There's been no negative repercussions whatsoever.
Thank you very much. And that's it. Unless anybody wants to have another panel. Is there a desire to have another panel? I don't think. Anyway, but I want to thank our presenters very much for their contribution to our study here, and especially Mr. Rawls for being up all night. And but you've been a great help to us. You've helped us understand a lot of different perspectives. So thank you very much for participating. And with that, I end meeting 67.